First of all, let me thank the organizers for having me here. But even if we wanted to, they could not have avoided me. So that is that. Doctor, first, let me invite our guests from abroad, Dr. David Armstrong, Dr. Campbell, Dr. Narasingan, and all of you, Dr. Vijay, Dr. Mohan, all of you on the dais, all of the leading experts in the field of diabetology in one room. Well, I have been asked to speak about what the society expects of doctors. I was very happy to speak about law to an audience of doctors because I thought I would not be called upon for any blunders that I make. But on the way here, I was informed, much to my shock, that there is a lawyer present in this audience. Dr. Campbell's wife, I was told, is a lawyer by profession. So, ma'am, I wanted to enter into a criminal conspiracy with you and possibly ask you not to call out any blunders that I might make while speaking about the law. But that was not to be, and possibly I was purposefully not introduced to you so that we would not enter into that criminal conspiracy. But don't worry, please don't call me out on any blunders that I make, because I intend to enter into a criminal conspiracy with you immediately after this function is over. So what does society expect of doctors? I believe, and I think that's the statement of the law also, that the law as well as the society does not expect a cure to be provided to every disease that comes before the doctors for a cure. That is not the standard of medical negligence in this country and not in any other country in the world. We do not expect that the doctor is able to cure, because I believe that though we refer to medical science as a science, it is not an exact science in the sense of engineering, for example, where the application of certain settled principles would give you the desired results without change. Because I believe that each human being, each human body, and the doctors here may correct me if I'm wrong, is unique in itself. And therefore, it is not possibly as in the case of any other exact science, to predict whether the application of a particular system of medicine, a particular molecule, particular type of treatment would result in the same results for everybody, every patient that comes before the doctor. So the law and the society does not really expect that a cure be given for every disease, because every treatment might differ as far as every patient is concerned. So I believe that what is expected is a standard of care. That is all that the law requires the doctors to deliver to a patient. Now, what is this degree of care that is required? Now, all of you are aware that we have two parallel jurisdictions to deal with while dealing with the cases of medical negligence and associated litigations. One, of course, is the civil litigation, the Consumer Protection Act, and all those. And the other is the case of criminal case, a criminal prosecution for medical negligence. Now, the standard of proof or the requirement of evidence or the standard of evidence required in both jurisdictions are completely different. While in while looking at civil litigation for proving medical negligence, what is required is only the preponderance of probability, what the lawyers and judges refer to as preponderance of probability. Now, this is where I think the requirement of certain requirements that are required to be that are necessary to be followed by doctors and institutions across the country become extremely relevant. Now, I've made a note of some things that I think are extremely important, because while dealing with civil litigation, there is this famous rule called the Boland's rule. Reference, that name comes from a famous decided case in the United Kingdom, which says that if you can show that the treatment protocol that would have been followed by a peer group. Now, there might be two different opinions held about the way to treat a particular condition. Both might be equally accepted, both might be acceptable in terms of science, in terms of theory, and all that we need to show, or a doctor needs to show, that he has adopted a methodology that was generally accepted by a group of experts. Now, here comes the importance of certain things which I think I will make a mention of. Now, one of the things that is necessary, as you all know. Now, before that, as far as criminal negligence is concerned, we have a completely different, level of evidence required to prove a criminal case. And the present, as far as India is concerned, it is not very easy to charge a case of criminal negligence against a doctor, because it goes through several levels of vetting, including at government level, the prosecutor is involved, and there is an appellate level also before a doctor can be charged of criminal negligence. Now, coming to the basic requirements of the law, and I'm saying this from my experience as a lawyer. For nearly 24 years as a lawyer and about 4 years as a judge. Now, what are the things that I would look for? Suppose a case came before me for decision, where a doctor is accused of medical negligence. Now, the first thing that is most important is documentation. Now, the importance of documentation cannot be overstressed. It is extremely important to have proper documentation at every level when a patient comes to you for treatment. Now, I will give an example, and I'm sure that most of you, all 90% or 95% of the doctors today, are documenting. The old system of writing case files would have gone. Now we have electronic records. 99% of the doctors, hospitals, institutions will now have electronic records. Now, interestingly, about electronic records, what I want to stress is with reference to a case that came up for decision before me recently. I will not go into the specifics, I'm not supposed to, I will not go into the specifics of the case. But I can tell you this, a particular document was created on a computer in a police station. It referred to the date of the document, because the printout was taken and submitted to an authority. The date given was 6/3/2022. It referred to certain events that took place on 5/4/2022, 5/3/2022 and 3/3/2022. Now, a complaint was raised that this document that was created in the police station was a manipulated document. The high-tech cell attached to the police of the crime branch, which is investigating the offence, went and found out that the document that had actually been created in February of 2022, and it had been manipulated to make it appear as if it was created on 6/3/2022, referring to certain events which took place on 4/2/2022 and 4/3/2022 and 3/3/2022. Now, how would this look if it were to come before a court? Now, the argument raised was, look here, we made a copy of some earlier document, cut, paste, copy. Cut, copy, paste is generally something all of us do. But what happened in that case is we don't know the truth. But how does it look on paper? The way it looks on paper is there is a suspicion regarding that very document, because the computer technician says, look here, this document was seen created with hashtag value or whatever they look at for looking at when the document was created. It was created on February. How do you refer to events that took place on 4 almost a month later in a document created in February? So this is the importance of this is, while you all have electronic systems in hospitals and while recording case history or whatever it is, please make sure that the dates, etc., are not in any way, the systems are not in any way creating a date different from the date on which it was actually created. Now, this is extremely important because when it comes to litigation, all this plays an important role. Now, it can happen because of some malfunctioning of the software or something like that, that a different date is shown. I just refer to this to show the importance of documentation. That is, I cannot overemphasize the importance of documentation. Now, I believe that as far as the Indian scenario is concerned, the maintenance of documents in electronic format, there are some standards that have been prescribed by the Ministry of Health and Family Welfare. So therefore, these, and this is an observation from a case, that poor records mean poor defense and no records mean no defense. Secondly, also connected with the documentation is consent. Now, the law requires that the patient be told and consent taken of his agreement to the method of treatment that you think is viable and should be followed in the case of that patient. Now, there might be situations where the patient is so emotionally charged, so emotionally upset, that it might not be possible to have a rational talk with him. What do you do in such circumstances? The law then gives you the privilege of having a talk with the family doctor, with the close relatives, because there might be situations where the patient is so emotionally upset, so emotionally unstable, or because of other conditions is incapable of giving consent by himself. So this is important. This must all be recorded. It must show, the records must show that there was informed consent for a particular system of treatment that you wish to follow in respect of a patient. Now, connected with this, more importantly, is the consent for diagnostic methods to be applied to determine the cause of disease or the reason for the disease, or the cause for the uneasiness of the patient, cannot be confused with the consent for the actual treatment. So there has to be two stages of consent. One is if you have to employ any diagnostic procedure, consent for the diagnostic procedure does not imply consent for the treatment itself. Now, coming to the case of a surgeon. Now, we heard Dr. Campbell speak about diabetic foot and all these things. I'm sure these are cases that come up, these are instances that come up before doctors treating diabetes at various points of time. Now you decide that a particular patient needs amputation at a particular level, but when you go in, when the surgeon goes and he feels that something more is to be done. Now, where do you get consent? The patient is on the table. So that is something where the law again gives you the freedom to decide that if to save the life of the patient or give him a better outcome from the treatment, the law definitely gives you the right to take that informed decision. But again, coming back to documentation is very important, that immediately after the procedure, you document what you saw, why you did something more than what was planned when you took him into surgery. So therefore, please keep in mind that this is something that is absolutely essential when you have to take a decision to do something more than what was originally planned. Now, what is the extent of information that you have to give to the patient? Now, suppose again you have a very emotionally charged patient. Now, there might be different thoughts, different principles, different theories of how to treat a particular condition. There might be opinions on how to treat a particular condition, different opinions with equal backing, scientific backing. It is your judgment as to which of these treatment protocols that you must follow. Now, you need not go to the extent of telling the patient that, look here, there is this treatment available, but the complications are this. There is this available, the complications are this. To the extent that he would not be able to take an informed decision, because he is not an expert, you are the expert. So the law does not really require you, the society does not expect you to actually go to the extent of telling the patient of all the risks involved. Of course, you have to tell him about the risks involved, but don't tell him too much that he will possibly refuse consent. That's not the requirement of the law. Now, privacy and confidentiality is another thing which the law expects, the society expects from doctors. Unless you are compelled by a court or by judicial order or by authority of an order issued by some statutory body, you are not supposed to reveal the patient confidentiality in any manner. Now, one aspect that has often come up is, at what point would you cause reference to a specialist center when you feel that the patient has come to a stage where he requires to be referred to a super specialty hospital or something like that? That is a decision that you cannot delay. You cannot, that kind of adventurism is not expected of doctors. At a point of time where you feel that apart from you're treating him for diabetes, you feel that he has got some cardiac problem that requires attention at a different level, you are not expected to do any adventurism, and you're supposed to make a reference as quickly as possible. Now, the law in this country also requires you to issue proper bills, inform the patient about the costs involved in following a particular treatment protocol, approximate costs of treatment. Now, this is Consumer Protection Act of our country, requires you to issue a bill giving details of whatever charges have been levied, and the improper issuance of a bill has been seen as an unfair trade practice. This is also something that I thought I should bring to your notice. Now, one important thing in India, we have, these alternate systems of medicine. We have Ayurveda, we have followers of homeopathy, we have followers of naturopathy. So, all different systems of medicine. Now, while you are you are qualified while you are qualified to treat patients of following a particular system of medicine. You're not expected or you're not authorized to actually prescribe a different system of medicine, because that the law does not recognize. You may be knowledgeable about a different system of medicine. It may have come to your attention that a particular medicine which is used in an alternate system of medicine is effective in treating, but then you should not take it upon yourself to prescribe that alternate system of medicine. This is also very important. Now, again, connected with record keeping, is retention of records for a reasonable period, so that any subsequent issues can be defended properly by reference to those records. The patient is entitled to the medical records, even if he does not pay your bills. He is entitled